Good evening, Facebook. Hello, 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 hello. I'm standing because I've just had my dinner and I'm very full. So I thought I'd stand up instead of sitting down and do the live video. Okay, so I'm here today because I had a very, very good news for two clients who obtained their permanent residence cards today. And it is especially very, very good news for them because they never expected. I think they made the application not knowing they were going to get it. But they got it today, and it was so, so wonderful to give the news to them, and so, so excited for them. So I'm not sure if they're watching, but yeah, really, really, really happy for the family. The other thing I wanted to discuss is about divorce. So a lot of people have, oh, Daisy, thank you. A lot of people have asked me about divorce. Okay, so these are kababayans who are permanent residents in the UK and who are probably have gone on to become British citizens, but have not filed their annulment in the Philippines, and they want to, obviously they have moved on with their lives and they now have partners, and so they've asked about how to apply for divorce. And so the time scale for divorce is, if it's very, very straightforward, so meaning when you file it and it goes in accordance with the procedure, then it should be quite straightforward, between 6 to 8 months, okay? And that is provided that the partner, the husband, the spouse, whom you are divorcing from, signs the paper. So it's called, well, they call it respondent. So court terminology, it's respondent. Petitioner is the one who wants to file divorce. And so the respondent, provided the respondent signs and returns the form to the court, then it goes in accordance to the time scale. Otherwise, if they don't, then you have to make another application to the court, asking them, hi Regine, good evening too, asking the court to let you proceed with the procedure, even though your husband or your wife or your civil partner has not signed the divorce petition that you sent to court. So that is the procedure. Sometimes if the husband or the wife does not acknowledge the form, and there is no proof, you haven't got the proof that they've actually received the petition. So what normally happens is that you send it to the court, and then the court sends the divorce petition to the address of your husband or your wife, the one that you're divorcing from, sends it to the court, and then silence. There is nothing that's happening on the case. Then, if you can't prove that this person actually received the divorce petition, then nothing's going to happen on your petition, on your divorce. Okay, so to actually move it forward, you need to then either you call, if you are still on speaking terms, you call the person, or you write them an email with a copy of the divorce petition, and then if they acknowledge that they received it, or when you speak to them, and then if they say something like, oh, you know, they've received it but they're not signing it, just to be difficult, then it's proof that they have received it, they've read it, and so that will be your evidence that they've received it. And so you make the application to the court, and the court will consider what you have written. In some cases, you may have to write your statement to say, for example, that you called on this number on that date, at what time, and what was said on that conversation. So that's the divorce side. So yeah, just a quick one, because I want to relax on my Friday evening. It's Friday night, and I wanted to just relax tonight. So just a quick one, just to share that I had very good news for clients whom I was very, very, very excited for to receive the residence card. You know, the EEA residence, permanent residence applications are so straightforward. I don't normally get excited about these things, but because they've had refusal before, so they were refused before, and also they didn't hold this residence permit as a family member for 5 years. So people believe that people believe that in order to apply for permanent residence card under the EU regulations, you have to have held 5 years of this card. But that's not the case. And I mentioned it before, that to apply for permanent residence card, you only have to prove that you have been married 5 years with an EEA citizen and you've lived with them for 5 years, and that's all you need to prove, and send the documents, so 5 years worth of bank statements, 5 years worth of proof of cohabitation, such as your bank statements, your bills, in the same address. That's all you need to prove, and then the Home Office will check whether the EEA citizen has been exercising treaty rights. They check the HMRC to see if they've been working all throughout this 5-year period. And that's it, you get your permanent residence card. But for these clients, they have only held it for, I think, 3 years or 2.5 years. And I said no, because the regulations, if you read the regulations, it doesn't say anything about the fact that you have to have held it for 5 years. Okay, so that's the difference. All right, guys. I know some people are joining me, and there's a few of you, several of you watching, but I'm finished for this week. Next week I will try and I don't know, maybe do a Christmas raffle where I will pick one name and I will do your application for free, something like that. Exciting. That's my Christmas present for whoever will be the winner. So I'm just thinking about what I can do to give back, because I know I've been doing this live, and I know some people have instructed me. And you know, for the existing clients especially, I wanted to give something back to them. And maybe for those existing clients or clients who instructed me before, who wanted to do another application or who wanted to consult me with another legal matter, and you know, money is tight and so on, but we can definitely do something like that as a Christmas present for me. Okay, so anyway, it's something I have to think about, but for now I'm off. Good night. Bye-bye.